You're watching Studio CF, the video law blog of Carlton Fields. My name is Mac McCoy. I'm a shareholder, business litigator, and member of the new media task force at the firm. I'm also your host for this episode, in which we discuss social media ethics for Florida lawyers, identifying 15 potential pitfalls for Florida lawyers and law firms using social media. Social media has exploded over the past several years, affecting many industries. The legal profession is no exception, which raises a very important question. How do Florida's rules of professional conduct apply to lawyers and law firms using these technologies? The short answer is, it depends. The rules apply or potentially apply in a lot of different ways, depending on how lawyers and law firms choose to use social media. This requires active consideration of what lawyers and law firms are doing with social media, how they're doing it, why they're doing it, and how the rules of professional conduct potentially apply in light of these considerations. For purposes of this presentation, however, we'll highlight the top 15 potential ethical pitfalls for Florida lawyers and law firms using social media under the existing rules of professional conduct in this state. Pitfall number 1, distinguishing between personal and professional use. There is an expansive gray area between purely personal use of social media and traditional types of advertising. It is fairly easy to fall within that gray area when casually commenting on day-to-day activities. Why is that distinction relevant? Because according to the Florida Bar's Standing Committee on Advertising, professional use of social media may be subject to the advertising rules, whereas purely personal use of social media is not subject to the advertising rules. The Standing Committee has promulgated two sets of guidelines. The first set of guidelines applies to networking sites, which include sites like Facebook, LinkedIn, MySpace, and Twitter. The second set of guidelines applies to video sharing sites, which include sites like YouTube and Vimeo. The guidelines say that activity on social networking or video sharing sites that is used solely for purposes unrelated to the practice of law, or solely for social purposes to maintain social contact with family and close friends, is not subject to the lawyer advertising rules. In contrast, the guidelines say that activity that is used to promote the lawyer or law firm's practice is subject to the lawyer advertising rules. Of course, the guidelines and the rules recognize exceptions for communications to other lawyers, persons who have requested information, or persons with whom the lawyer has a prior personal, familial, or professional relationship. Pitfall number 2, false or misleading statements. Lawyers are prohibited from making false or misleading statements. That includes statements made through social media that may be deemed false or misleading. So the bottom line is that lawyers and law firms using social media for professional purposes must consider and evaluate whether their activities could be construed as false, misleading, manipulative, or confusing in violation of the rules. Pitfall number 3, improper solicitations. The rules impose many limitations on a lawyer's or a law firm's ability to solicit legal employment. It is easy not to think about a friend request or a LinkedIn invitation as a prohibited form of solicitation, but it may become a solicitation under the ethics and advertising rules if a lawyer is not cautious. Problems may arise, for example, in the case of social media communications to non-lawyer third parties with whom the lawyer or the law firm have no prior relationship. Pitfall number 4, friending judges or mediators. On November 17, 2009, the Florida Supreme Court's Judicial Ethics Advisory Committee issued Ethics Opinion number 2009-20, which concluded that judges cannot friend lawyers who may appear before them on Facebook, because doing so would violate Canon 2B of Florida's Code of Judicial Conduct by suggesting the lawyer is in a special position to influence the judge. A key factor in the committee's view is the judge's ability to selectively accept or reject friend requests, which, as we all know, is central to the way Facebook and many other social networking services function. Subsequent ethics opinions in Florida have confirmed this rule and extended it to judges who connect with lawyers on LinkedIn. Interestingly, however, an ethics opinion by the Mediator Ethics Advisory Committee found that mediators may designate mediation clients or parties or attorneys who participate in mediations with the mediator as friends on social networking sites and permit clients or attorneys to add the mediator as their friend. However, mediators must determine whether the nature of their relationship with an attorney or a party through social media represents a potential conflict of interest or would impair the mediator's impartiality. Pitfall number 5, inadvertently creating attorney-client relationships. Attorney-client relationships can be formed through online communications, including communications through social media. Because social media allows users to communicate and interact with each other in a virtual environment, if they are not cautious, it is possible that lawyers and law firms may inadvertently create attorney-client relationships with non-lawyer users of social media when communicating regarding a specific matter or when discussing the possibility of forming a lawyer-client relationship with respect to a matter. Pitfall number 6, inadvertently disclosing client confidences, privileged information, or work product. The danger here is created by the tendency of many social media users to casually describe, comment on, or broadcast their day-to-day activities, including work-related activities. Lawyers must therefore consider whether social media posts could potentially reveal any confidential, privileged, or other non-public information concerning the legal work they're doing for their clients. Pitfall number 7, conflicts of interest. Conflicts issues can be extremely complex. It's important for Florida lawyers and law firms to actively think about whether their social media activity may give rise to potential conflicts, particularly when communicating with non-lawyers through social media. Pitfall number 8, investigating and communicating with represented parties. A lawyer cannot communicate with a person the lawyer knows to be represented without the consent of the represented person's lawyer. Moreover, lawyers cannot use agents or third parties to communicate on the lawyer's behalf or induce others to facilitate an ethical violation. Therefore, lawyers and law firms should be particularly cautious when, in representing a client, they use social media to investigate or communicate with parties whom the lawyer knows to be represented by counsel. Pitfall number 9, investigating and communicating with unrepresented third parties. The rules of professional conduct impose several restrictions and obligations on lawyers and law firms when investigating and communicating with unrepresented third parties. These same obligations apply to the use of social media in essentially the same way they would apply to other forms of communications like telephone calls, letters, or emails. Pitfall number 10, commenting about judges or pending matters. The rules of professional conduct prohibit Florida lawyers from making extrajudicial statements that lawyers reasonably should know will have a substantial likelihood of materially prejudicing an adjudicative proceeding. The rules also prohibit Florida lawyers from assisting another person to make such statements and require lawyers to exercise reasonable care to prevent investigators, employees, or other persons assisting in or associated with a case from making extrajudicial statements that are prohibited. Lawyers and law firms must consider these restrictions before commenting about pending matters in social media. Lawyers should also be very cautious in blogging, tweeting, or posting opinions about judges. The rules of professional conduct expressly prohibit lawyers from impugning the qualifications and integrity of judges by making statements that the lawyer knows to be false or with reckless disregard as to the truth or falsity of the statement. The rules also broadly prohibit lawyers from engaging in professional conduct that is prejudicial to the administration of justice. Thus, extreme caution is warranted before making any such statements on social media. Pitfall number 11, testimonials and endorsements. The advertising rules in Florida restrict the use of testimonials and endorsements. It is important, therefore, to know, to understand, and to comply with the relevant rules before engaging in such activities on social media. Pitfall number 12, non-compliant posts by third parties. The guidelines promulgated by the Florida Bar Standing Committee on Advertising relating to social networking sites state clearly that lawyers and law firms have an obligation to remove third-party posts on social networking sites that violate the rules, if doing so is within the lawyer's or law firm's control. If doing so is not within the lawyer's or law firm's control, then the lawyer or law firm must ask the third party to remove the offending post. If the third party refuses, then the lawyer or law firm will not be in violation of the rules. Pitfall number 13, multi-jurisdictional practice. When using social media, all lawyers must be mindful that their friends, followers, or other social networking connections can be reading posts from anywhere in the world. Suffice it to say that lawyers and law firms using social media must be conscientious about how their usage might be governed by the relevant rules in Florida and possibly even outside of Florida. Pitfall number 14, pay-per-click or banner advertisements. The use of pay-per-click and internet banner advertisements is regulated very closely under the Florida advertising rules. Lawyers should understand how these types of advertisements work, which may require Florida Bar approval prior to publication, and consult the relevant rules before attempting to use them for legal marketing purposes. Pitfall number 15, friending opposing counsel. The bottom line is that if you connect with someone through a social networking service, you must appreciate that that person, and depending upon your privacy settings, potentially all of that person's other connections, will have access to the information you post. This may give an opposing lawyer not only valuable insight or intel about you, but also about your clients. It's the social media equivalent of allowing opposing counsel access to your Outlook calendar and contacts. That brings us to the end of this episode of Studio CF. We hope that you found the discussion informative. Please take a moment to browse our other legal topics and be sure to check back with us each month for new episodes. Thank you for watching.